Absolutely. Thank you, everybody, for joining us. Welcome to our presentation today. We're really glad that you are able to join us. The webinar title, as many of you know, is Litigating the LTD Bad Faith Case, Lessons from Baker versus Blue Cross, featuring our two presenters today, Steve Rastin and Stephen Birman. Again, very happy that you chose to spend time with us today. Reminding that this meeting is being recorded and we will be utilizing the Q&A function throughout the webinar. So we will gather those, and then at the end of the presentation, happy to bring those questions forward to our presenters. This webinar, thankfully, is a collaboration between LexisNexis and Gluckstein. We're glad that we could be able to offer this to you today. Before we get to the main event, the team at LexisNexis is just going to do a brief showcase of the Lexis Plus AI product. So I'm going to send it over to them to do that, and then we will head right into our webinar presentation.
Hi, my name is Peter Savitas. I'm a lawyer and practice area consultant for Mid-Law and Large Law Canada. And today we're going to be looking at some examples for insurance litigators, particularly with respect to Lexis Plus AI. Starting off, we're going to ask the system a general question. The prompt is, are CPP benefits considered an offset in long-term disability cases? What Lexis Plus AI does is it does not perform the legal research in traditional methods. It uses two large language models in order to synthesize information while also drawing from LexisNexis content, both primary and secondary materials. This method of legal research is a lot different because it's not just providing you with cases or paragraphs or secondary materials. It's amalgamating and synthesizing that information and generating a response rather than just providing you a list of the materials that are related or relevant to your search. Here we can see with the prompt that I've created, yes, CPP benefits are generally considered an offset in long-term disability cases. This is correct. Now, for an insurance practitioner, this might be very, very obvious. A lot of insurance practitioners deal with this issue all the time. So let's deal with a much more complicated scenario. Say, for instance, you're looking at a policy of insurance. I have an example of one right here. And there's a dispute as to whether or not the insurer is going to pay for an experimental treatment. Your position, maybe, or as the plaintiff, is that it's not an experimental treatment. It's not being done for research purposes. It's a novel treatment, but it's not experimental. So you want to see whether or not you can get around this clause. And that clause is contained in Section 6 of the exclusions clause of this insurance policy. For any products, devices, services, or supplies used for experimental purposes or at medical research stage, there would be no insurance coverage provided or coverage for those expenses. We're trying to get around that. So let's try the following. Let's ask the system, do insurance contracts that stipulate that medical benefits will not be provided for any drugs, products, devices, or services used for experimental purposes of medical research exclude novel treatments that, while not used for the purposes of experimentation and research, are nonetheless unprecedented? So a bit of a different argument to try and get around that clause. Let's see how the system performs with such a problem. You can see here, even with a more complicated prompt, drawn directly from a provision from the insurance contract, I'm getting an answer leveraging a variety of case law and secondary materials in order to be able to answer this question. This can help me or assist me when I'm trying to make a more novel legal argument or trying to argue that a particular clause should not be applicable or should be read in a different light. Now we're going to ask the system to generate a legal memo. Draft a legal memo outlining the cases whereby the courts awarded punitive damages in long-term disability cases. Here you can see this created a memo with headings. Here we haven't included the facts. It's including the applicable rules. And we see here one of the seminal cases that was fairly recently argued in Baker v. Blue Cross being cited within the legal memo. If I'm looking to get a summary of Baker v. Blue Cross to understand what happened further, I can click on the citation. Go to summarize the case. I've copied and pasted the citation, and I'll have Lexis plus AI perform this task for me. Here, we can see that this was an appellate decision, and it's providing you the key material facts, the issues, the legal findings, the applicable law, the ratio, and the procedural outcome. Now we're going to utilize the upload documents and ask questions feature on Lexis plus AI. Say, for example, you're looking at your file and you want to summarize some of the medical history of the claimant. You can get Lexis plus AI, and it'll provide a summary of the file. From here, you can ask questions. I'm asking the system now, based on Jim's medical history, whether or not Jim exhibited any violent tendencies. When you upload documents into Lexis plus AI, your data is encrypted and is not visible to any third parties or to LexisNexis. All of the data and all the files that you upload into Lexis plus AI are fully secure, and confidentiality or product privilege is protected. As you can see, when asking the system whether or not Jim exhibited any violent tendencies, it was able to scan the document and advise whether or not Jim had any violent tendencies. Many litigators, law clerks, and paralegals that work in the insurance litigation field utilize medical evidence in order to build their case or to refute whether or not a claimant is entitled to benefits. In order to do this, you add the summaries and the history of the claimant, what they're suffering from, to your mediation memo or to your submissions to the tribunals, wherever the level of court or tribunal that you're arguing in front of. One thing that you can do in order to be able to assist you in this task is to say the following. You can take the summary, copy it, and with that summary, you can ask the system to do the following. Draft legal arguments in support of Jim continuing to receive long-term disability benefits based on the summary below. Now, many of you will know that with summaries and asking or drafting a mediation memo in support of your claimant continuing to receive long-term disability benefits, this could take some time. Here, we're just copying and pasting a summary that the AI has created, and we're trying to see whether or not the AI can make the argument for us. Utilizing just the summary that I was able to obtain from Lexis plus AI in a matter of seconds, copied and pasted it into our drafting section, you can see that the AI has parsed out the key facts from that summary in order to develop an argument as to why, based on his medical condition, he should continue to be on long-term disability, and why he's unable to perform the duties of any occupation. I did not even include that in the prompt. The AI was sophisticated enough to understand that that's part of the test in receiving long-term disability benefits. And here it outlines the reasons as to why he should continue to receive benefits. Other use cases from the upload and ask feature. Many of us as former insurance practitioners have retained experts who are looking at expert credibility. So one such example is you could take, for instance, the CV of a medical expert. Here we have the curriculum vitae of Dr. Cyril Wecht. This medical expert has been involved in many cases, particularly as they relate to forensic pathology. So let's get the system to help us draft arguments in support of Dr. Wecht's admission as an expert. Here we have the CV again, same process, copy and paste the summary, have Lexis AI do the work for you. And now I'm asking the system to draft legal arguments in support of admitting Dr. Wecht as an expert in forensic pathology based on the summary below. You can see here, again, the AI has parsed out the relevant facts in order to be able to create the argument that Dr. Wecht should be admitted as an expert in this for forensic pathology, and supporting case law that would establish or further support why it should be admitted. Now, lastly, another thing that a lot of insurance practitioners do is there's a lot of independent medical exams, both from plaintiff and defense. And so we want to examine whether or not certain independent medical examiners are credible witnesses, or whether or not we can attack their credibility. So let's take the example of a neuropsychologist or neuropsychology expert, Dr. Lawrence Friedman, as an example. We want to see whether or not the courts have ever criticized or opined on the credibility of Dr. Friedman before. So let's see. The prompt says here, have the courts ever criticized Dr. Lawrence Friedman's objectivity or testimony? Dr. Friedman is purported to be an expert in neuropsychology and neuropsychological impairments. So let's see, how credible is Dr. Friedman? Let's have the AI figure that out for us. And you can see here, yes, we do have court cases that opine or are critical of Dr. Friedman's objectivity and his ability to provide testimony. Particularly, it cites Counsel, a 2022 decision where the judge stated that Dr. Friedman was either less experienced than he professed or was trying to avoid disclosing necessary records. So if being provided with either a plaintiff or defense medical, now you can stress test whether or not that medical expert is a credible witness. If you want to find out more about Lexis Plus AI and how it can help serve your practice, feel free to contact me or your account executive or account manager, and we'll be happy to set up a meeting for you.
Thank you to the team at LexisNexis for that showcase overview. Now on to the reason why everybody is joining us today. So again, thank you for your patience. Thank you for being with us today. I'm going to dive right in. I'm going to hand this over to Steve Rastin, who is going to go ahead and start the introductions. And again, reminder of the Q&A feature. We look forward to any of the questions that you may have as we move forward with our presentation. So thanks again.
So I want to thank everybody joining us on a summer day to have this conversation. As good a job as LexisNexis AI has done talking about the Baker and Blue Cross case, we're going to do one better today. In trying to pick a topic that we thought people would be interested in my view, the Baker and Blue Cross case is the biggest case to come out of LTD litigation that I can remember. Is one of the biggest civil litigation cases in a long, long time. And so we reached out to the guy that decided the case. Stephen Birman is a partner at Thomson Rogers. He practices in a number of different types of practice areas, including class action, mass tort. I'm not going to go into it, but what makes Stephen particularly interesting for everybody on this call today is Stephen is the guy that had the courage to take this case to trial. Won the case on appeal. He's got a thriving practice. He's done cases at the LAT, he's done cases in the courts, and he's done this LTD case. And we're privileged to have him here with us today. So Stephen is going to take us through, and we're going to have some conversations about the tactics, decisions, and history of this case as we go forward.
Thanks, Steve, for that kind introduction. I didn't decide the case. That I'll leave that to the jury and the Court of Appeal, but did argue the case at both levels of court. And I really want to thank you, Steve and Gluckstein, for inviting me here today to talk about the case. Steve, I've a ton of respect for you and your career. For those who don't know Steve, he's spent the last 30 years practicing in personal injury law and medical malpractice and basically everything you can think of. He's got experience at all levels of court in Ontario, up to the Supreme Court of Canada. And most importantly, what I really respect about you, Steve, is that you've given back tremendously to the legal community via OTLA in particular, where you're a past chair of the LTD section and also a past president of OTLA, which is just an amazing way to give back and also just constantly participating in these types of legal education seminars. So feel very privileged to join you here today, Steve, and talk about the case. I will dive deep into the case, but Steve, cut me off as I'm going along, because as you can imagine, I could talk about this all day long, and I know we have a number of different topics we want to cover. So
why don't we start by, why don't you tell people that may not know the case, why don't you go over the key facts and background of the case and just give people the overview from 10,000 feet?
Sure, my pleasure. So the case involves my client, Sarah Baker. Sarah was, back in 2013, she was a 38-year-old hospital administrator. She had a very successful career working at Humber River Regional Hospital over 12 years. She'd been promoted multiple times over the years. She was going big places at the hospital. And suddenly in 2013, while she was exercising, and that's an important point because exercise is a theme that fit into the trial in a lot of different ways. While she was exercising, she suffered a stroke or a subarachnoid hemorrhage. She was hospitalized for several days, and she wasn't able to return to work. In the weeks and months that ensued, she developed various symptomatology from her stroke, including constant debilitating headaches, cognitive issues, fatigue. And she did what anybody would do, which is she applied to her group insurer, Blue Cross, which was the insurer at her employer, for long-term disability benefits. And she went through the process. Little did she know where the process was going to take her back in 2013. But she initially applies for benefits with Blue Cross in the aftermath of her stroke. She's accepted, as you would expect, early on. But within a couple of months, her claim is denied, which, looking at the file then or 10 years later, I would think would have been surprising to most, because she had a very significant health condition, and one in which Blue Cross, in their own manuals, which we'll talk about when we get to the production stage, in their own manuals described as a potentially career-ending condition that would be of permanent duration. So her benefits denied early on. After it's denied, she appeals that denial. Blue Cross then sends her claim to its internal medical consultants, who don't see her but review the paperwork. And they very quickly, at that first denial, reinstate her benefits. From there, her condition continues to really plateau. She's not getting better. She's seeing lots of doctors. About a year or so goes by. We're still in the own occupation period under the policy. And Blue Cross once again denies the benefit without giving Sarah an opportunity to provide new information, without doing any type of independent medical evaluation. And once again, Sarah is very upset by that, as you can imagine. She begins the appeal process again. It goes on for many, many months. She provides lots of records, lots of documents. There's some internal medical consultant review that's done. And eventually they say, you know what, I think we should send Sarah for an IME. And they send her to see a doctor for the first time. This is now about 2 years into the claim. And they send her to see a neuropsychologist named Dr. Kimberly Kane, who assesses Sarah in the own occupation period. And she comments that Sarah's not able to return to her job as a hospital administrator, but that she may be able to return to some other type of modified job in quiet settings, doing some type of one-on-one counseling with limited feedback, if the job exists, and if her own doctors support her ability to do that type of work from the perspective of her headaches and fatigue, which were conditions that Dr. King couldn't comment on. So Blue Cross gets that report. They reinstate the benefit now for a second time. We're now approaching the change in definition. And then they immediately tell Sarah that they're going to review her claim again on change in definition. And they have her seen by another one of their assessors named Cynthia Kresak, who does what's called a transferable skills analysis. I'm sure many on the call today have seen these types of reports before. That report comes back right around the 2-year mark and says there are 6 jobs that are suitable for Sarah that meet the criteria under the policy, namely that are commensurate with her education and experience, and that pay 60% or more of what she was earning before her disability. As it turns out, on a close reading of that report, 5 of the 6 jobs paid nowhere near the 60% threshold, and the 6th one barely met that threshold and had a number of issues associated with it. So Blue Cross takes that report and they deny the benefit for the final time, which leads us into a final appeals process that's denied again, and then finally leads us into the litigation. So Steve, would you like me to talk a little bit about the litigation and the
So let's move forward. So we got all this background, and one of the couple of the key takeaways, and I think people want to see this, and I see this all the time. We get these transferable skills analysis, or we get these write-ups, and it's amazing to me, Steve, how often these things are just like, like they fold like a wet tent in a thunderstorm. They make assumptions, we're going to assume our client has equivalent to high school when your client dropped out in grade 9, or these jobs make 60% like your case when they didn't. I mean, my perception is that counsel need to look real hard and real careful at these transferable skills reports. And I'm just wondering if that's something that you felt was live in this case.
Well, I mean, that was very live in this case, and I would have thought would have been obvious on any reading of this report. Like I said, where 5 of the 6 jobs don't even meet the 60% threshold. But then when you start to dig deeper, beyond even what's in the report, I think it's important to talk to your client about the experience associated with each of these assessments. We often hear from our clients about how poorly they feel like they were treated at an assessment or what have you, and it's not something that makes its way, necessarily into mediation memos often. But when you get to trial, when you get to court, your client has an opportunity to talk about what actually happened at that assessment. How long was that assessment? What questions were asked? In this particular case, with this assessor, she didn't even have a copy of my client's CV. Okay. You would think that would be a very basic threshold thing to want to have, right? If you were doing this type of skills analysis. So yeah, I think there are many ways to look at these reports and dissect them.
So let's move forward to the trial process, because one of the things that I think is shocking about this trial, I've had lots of trials that have surveillance. And a lot of times I will take the surveillance evidence and I actually show it to my client in chief. And I've been yelled at by judges for how boring it is to show this to my client. I had one judge yell at me once and said it was like watching paint dry. But I still think it's important to show it to the judges and the jury, to show them this is actually what they use to cut your client off. But in your case, I guess you couldn't show all the surveillance, right, Steve? Why don't you tell the people watching the surveillance that was conducted in this case and how it was used at trial?
Yes. So Blue Cross in this case conducted a lot of surveillance. There was, I believe, 13 hours of videotape in total that was taken over 20 or so days and 350 hours of surveillance time. They did not use it for impeachment purposes in any way, shape, or form, and that's because I made sure to inoculate Sarah against anything in the surveillance. And frankly, the surveillance was all consistent with what she had disclosed at discovery and over the many years of her case and in chief. So Blue Cross used the surveillance for substantive purposes as part of their case. They called an investigator who went through about 2 hours of it on the stand. There was a discussion or debate. There were some motions on the surveillance. Firstly, whether it was admissible at all or not, and ultimately Justice Fella admitted the surveillance. But there was a secondary discussion about, well, how much of it could Blue Cross show? There are obviously proportionality issues associated with when you have this quantum of surveillance. There were questions as to whether the surveillance should go to the jury, the parts that weren't shown. But in the end, they showed 2 hours through their investigator. I will tell you, from my perspective, it was quite dry. I don't know how the jury felt about it or responded to it. We'll never know, other than perhaps through their award at the end of the day. But having heard my client's evidence, Sarah's evidence, and then having watched surveillance that was effectively consistent with her evidence, I'm not sure it was particularly effective. I would think that typically good surveillance would have an impeachment value. So it was a big part of the trial. It was certainly a big part of Blue Cross's defense. They insisted on having a jury in this case. They filed the jury notice in part on the view that the surveillance would be meaningful. That was the argument they made on a motion we had to strike the jury during the COVID pandemic. So the surveillance played into the trial. How effective it was, I'll leave others to decide.
I'm even going to go one step further, because in my experience, especially when you've got a female plaintiff and you've got, an old white guy sneaking around in the bushes following her around, my subjective feeling watching jurors watch surveillance is sometimes they find it intrusive. they find it offensive. And, you know, I got to think, and we're going to talk about the verdict in a second, but I got to think that the jury, in expressing its verdict, it's logical to think that they were expressing some disapproval with the way that Blue Cross surveilled your client and put her through the ringer. I mean, what do you think of that?
I think the general public would be surprised to know that surveillance is a common litigation tactic. I think most people that haven't been involved in a litigation case don't realize that insurance companies use this technique. And I think there are a lot of people who are surprised and may learn about it for the first time. So if you're going to use it as part of a litigation strategy, it's you're going to have to get over that threshold hurdle in the jurors' minds, and it's going to probably have to be persuasive.
So before we get to the verdict, and I do want to talk about the verdict, let's talk about the actual process of building the case. I mean, one of the things that you alluded to, that you talked about, is you actually had the claims manuals, or some of the claims manuals here. And if I had $1 for every case where I was told we have no claims manuals, we have nothing in writing, these people come in and they do an 8-week on the job shadow, and then they do it. We don't have anything in writing. And there's a recent case on producing claims manuals that have just come out. And I think the sort of shell, the argument that their claims manuals don't exist, you know, it doesn't really pass the smell test when you think about it. When you got these multi-billion-dollar companies with millions and millions of dollars in claims and stuff. Your case, the manuals to some degree came out, Steve, and they were used, right? So can you tell the people watching this about that?
Yeah. So in my case, what was relied upon heavily were actually their internal medical guidelines, which, to their credit, Blue Cross produced voluntarily. We didn't need a motion to pursue that. But their internal medical guidelines, which they have a guideline for every medical condition. So they had a guideline that described subarachnoid hemorrhage and exactly what the condition is and what the recovery period is and what the recommended rehab is. And every claims handler, and there were many who touched this file, had access to it and referred to it in their progress reports, or the reports they prepare every time they update the file. So there was a tremendous amount of good information in there that they had to know and they had to admit, because it was the information they relied upon about the condition itself, including things like expected recovery time. In the case I think you're referring to is this recent case, this Heathcote versus RBC life insurance case. Yeah. And I know Brendan Sullivan, who I think is on the call, argued that motion, and credit to him. I think it's a great decision. You know, he was able to get the claims manuals. He was able to get all sorts of witness information, all sorts of things that you'd think would be obvious parts of disclosure in any discovery in these cases. And I don't know why, Steve, like why we would in any case have an insurer tell us that these things don't exist. I mean, that's inconceivable that the big insurers don't have these manuals.
We do know, Steve, that we hear this story over and over and over again. So credit to Blue Cross for giving it, but I have been told more times than I can count that kind of documentation, training manuals, all that kind of stuff just simply doesn't exist. And I guess, you know, the message from your case and the message from it was Brendan's case, right? Brendan Sullivan's case,
RBC life case, yeah.
You know, the RBC life case is, don't you believe him, or at least take a long, hard look at it, because you know, Stephen got admissions from those internal notes, from those guidelines that helped getting to the verdict. And Steve, let's sort of turn to that. I mean, after listening to the surveillance and the doctors and the transferable skills analysis where 5 or 6 didn't fit and everything else, what did the jury come back and do in that case? And what insight can you give us as to what made the jury maybe do what they did?
So for those who don't know, the jury came back and ordered or found that Sarah was totally disabled under the policy, and she would receive her benefits retroactive to the date of the verdict. They awarded aggravated damages for mental distress associated with the denial of her benefits of $40,000, which is a significant number. The Justice Vela had put a $20,000 number to the jury, so that tells you how they felt about how how this affected Sarah's mental health. And they made the landmark award of the $1.5 million in punitive damages on account of their finding that Blue Cross acted in bad faith and that punitive damages were warranted.
So, I mean, we've got this big punitive damage award, which is 5 times the size of the amount outstanding, right?
Yes.
Right.
Roughly,
So roughly, I mean, 200 and something outstanding, $1.5 million in punitives. But it wasn't just the jury that was upset at the insurer's behavior. There were comments that the judge made in the cost decision that indicated that the judge that heard the case had some sympathy for your client in her case and how the case was argued. Why don't you talk about the cost award a little bit?
Yeah, so I think the cost award is really interesting. The Justice fell in her cost award really had 3 avenues that she could get to arrive at our position, which was that full indemnity costs were warranted. So one avenue was the one that she landed on, which was Her Honor landed on, which was based on the category of contract, and namely that this as a peace of mind contract and these as contracted benefits should not be dissipated by legal fees. Her Honor could have also awarded full indemnity costs on the basis of Blue Cross conduct, and she could have also ordered full indemnity costs, I would argue, on the basis of our Rule 49 offer to settle for reinstatement, which was obviously dwarfed by this verdict. And Her Honor went with the category of contract reasoning, which was reversed by the Court of Appeal. The Court of Appeal accepted full indemnity costs were warranted, but relied upon the offer to settle and Blue Cross's conduct. They did not want to get into this discussion about whether this category of claim should automatically attract full indemnity costs. I think there was some sympathy to that argument at the Court of Appeal, to be honest, but they left it as something that should be considered by the Rules Committee at the end of the day.
And it's interesting. I mean, going back with that, years ago, we had a great lawyer from British Columbia, Faith Heyman, come up, and she talked about a bad faith case she did decades ago called Fiddler. And back in Fiddler, the Supreme Court of Canada was affirming that these are peace of mind contracts, and you can expect damages to flow from turning around peace of mind contracts. And that's an argument I'm just going to suggest, even though the Court of Appeal has gone there, I don't think that issue's dead. I think it's going to require a close reading of the Court of Appeal's decision. But the whole concept of peace of mind contract and the fact that, when do you really need coverage? When you're off of work and you can't pay your mortgage and stuff, that's when you can least afford to fight. And so that idea that we should pursue this, at least as a factor that the court takes into consideration, I think it's a live issue going forward. And I'm just saying, I read the Court of Appeal decision. I know what it says. I don't think that argument is dead. I think on another day, it's out there to be made. But what I agree with you. What I do want to turn to is, on a couple tactical considerations. So number one, we do have a question here from Brendan. We might as well work it in now. Stephen, did you see any issues of doctor shopping coming up, switching from doctor to doctor within the same discipline or anything like that on the other side? Because it sounds like they had your client go to one doctor and then another doctor and paper reviews and then in person and stuff. I mean, any of that in play here?
So yes, major issue. It was in play in terms of their internal consultant reviews, where each time they sent the claim to a different internal consultant for reasons that I couldn't understand. It was also, I would say, it was in play in the litigation itself. So I don't think a lot of people know about this motion decision, but recognizing, I think, the frailty in Dr. Kane's opinion, when we got into the litigation, Blue Cross sought to have Sarah examined by another neuropsychologist, Dr. Dohaniak, who I think is well known in terms of doing these types of medical legal assessments. Of course, we'll never know what he would have said, but I oppose that motion. There's a reported decision on it, and the court effectively said Blue Cross wasn't entitled to a second neuropsychological assessment. If they wished, they could send Sarah back to Dr. Kane for an updated assessment, and they never did. So yes, both within the claim process and the litigation process, that was on my radar. And I think it should be on everyone's radar when you're reviewing these files. They're not easy to review, these claim files, for anyone who's gone through them. Like it's tedious, takes a lot of time and effort to actually figure out what the process was. But it's worth doing because of what you can find in there. And then also give thought in the litigation process when the insurer requests IME assessment through the Courts of Justice Act. Give thought to whether they're duplicative and or not, because if they've done those types of assessments in the courts of handling the claim, I don't think they're entitled to get a second kick of the can.
So your answer makes me have another question for you, and this is, and I think this is good for the people listening to this. When you add up your motions, your submissions for cost, you're going to the Court of Appeal, you're doing the trial. How many times did you end up arguing something in this case? I mean, it sounds like you got multiple motions, trials, appeal. How many times did you end up arguing something in front of a decision maker on the Blue Cross file? 5, 6, 7, something like that?
Well, if we're including trial motions, then probably more than 10. We're not including trial motions.
And I just want to speak to that. I had a case I was successful on years ago. I got a big punitive award against Pilot, called Pilot and Miss G. And in that case, they said no to my client every single time. I ended up going to FISCO, as it then was, judicial review, divisional court, Court of Appeal, 9 times on that case. And that's what it required to get justice. And I guess the only point that I want to, sort of stress is, until we move the needle on these cases, we might have to do what I did on Pilot and Miss G, or what Stephen did on this case. It might require, and it probably is going to require, having the fortitude, the willingness just to keep up. And you know what? I didn't win every motion or hearing on Pilot and Miss G, but every time I lost, I appealed. And I didn't stop until I won. And that's not going to happen on every case. But you know what? It's the same thing for Stephen here. He didn't win everything, but he won almost everything. And look where it got him. And sometimes I think we look at a full cabinet, we look at everything that's going on there, and we say, is it really worth the risk reward stuff? Well, here's a case where a $200,000 case turned into a $2 million case because, Stephen, it's $1.5 million for the punitives. And what was the cost award? $1 million plus?
$1 million plus, yeah.
So that's 2.5. So you're what, 2.8 million all in or something that you're getting a check from Blue Cross from?
Roughly, something like that. Yeah.
Right. On a case that at mediation, and this is, I want to talk about tactics here. If you had done a mediation and you had settled this for a percentage of what the case is worth, look at the money that we're leaving on the table. And I guess that's one of the things I want to talk about on tactical considerations. There is an industry practice that's arisen of, let's mediate these cases super early, even before discoveries. Let's get a number, let's get in, let's get out. And I guess the takeaway tactically I want to say to that, and we're going to tie this into the discussion about the offer to reinstate, is on the right case, maybe that is okay. If your client's 50, 55, 60 years old or something, and and it's out there, it's okay. But how old was your client, Stephen?
So she was 38 when she had her stroke, and she was 47 by the time we got to trial.
Right. So, I mean, when you're dealing with a 38-year-old, I run into these problems all the time. It is, in my view, super hard to settle these cases early when you're dealing with a 38-year-old. And as an industry, maybe we ought to consider, when your client's young, whether that makes sense. And maybe instead of doing an early mediation and settling, we need to look harder on this tool of offering to reinstate. And Stephen, why don't you talk about how the offer to reinstate was used in your case, and how you think it impacted the analysis and how the trial played out?
Yeah, so didn't impact the trial because, the offer obviously is admissible at trial.
Yeah,
although
I should have made that clear, but
yeah.
what I mean is, when the judge was considering the cost issues, like the cost part of the trial is what I meant to say.
Yeah, no, understood. So the offer to reinstate, I can't remember when it was made. I don't think it was made that early. It probably could have been made earlier. It was probably made after mediation, but I can't remember. But it was an offer to reinstate, right? No, waiver of all extra contractual, release of all extra contractual claims, reinstatement, partial costs, and it obviously wasn't accepted. It wasn't addressed in the cost decision by the trial judge. It was addressed by the Court of Appeal. The defendant tried to argue there was some uncertainty in the offer that made it an invalid Rule 49 offer, and the court said by any measure the verdict is far exceeds the offer, which seems quite obvious given the award. So it was very helpful, I think, in terms of the cost award. But yeah, I think my recommendation would be to make these offers. I'm not sure that there's any downside in making an offer to reinstate. The worst thing that happens is the insurer reinstates your client's benefits, and then you're into a discussion about costs. I suppose you give up your extra contractual claims. So if you feel really strongly about them.
What I hear when I've got a 30 or 40-year-old client all the time is, well, we don't want to consider reinstatement because she's too young. And I mean, let's face it, it does put the insurer in a difficult situation. If you litigate and reinstate, I think it's not going to be that easy to cut your lady off in 2 or 3 or 4 more years. And so I can understand there's some practical reasons not wanting to do that, but as a tool, right? Why wouldn't they reinstate? I say it all the time. Well, I don't know if I don't know if your client's going to get better, or, what if she gets over her cancer? What if she gets over her depression? And I routinely say, well, reinstate her. 3 years from now, if she can work, she's going to want to go back to work. And that's what the coverage is intended for. But I think sometimes our friends at the other side of the table are trying to make the business decision. And the business decision is I'm dealing with a high risk young person. I don't want to deal with somebody on claim for 20 years, and I'm going to make that decision. And so an early offer to reinstate, I think, makes, sense. I've also had cases where I offered to reinstate without waiving the contractual claims. And I've had cases where on the edge of trial, they have reinstated. And I had one case I actually started the trial just on the bad faith. We settled it halfway through for bad faith damages, but, you shouldn't always consider whether you want to waive. In the few minutes we have left, Steve, I want to turn to some tactical considerations. One is, I hear this complaint all the time. I speak at conferences and I hear it from defense counsel. Every single LTD case has got a bad faith component. You're asking for $1 million and, it's boilerplate and everything else, right? And I agree with that. I don't always sue for bad faith. I always sue for aggravated damages, fiddler damages, okay? Because I think those are compensatory, not punitive in nature. But when a case comes in and you're looking at it and you're trying to decide, when is Baker versus Blue Cross 2 coming in your door? What are you looking at when the claims file comes in, Stephen?
Yeah. So, I mean, one of the challenges is you don't always have the claims file when you have to issue the claim, right? Oftentimes we're getting retained at the 2-year mark. We don't get a claims file for whatever reason. They're sometimes hard to get from insurers for whatever reason. So, when it comes to, we're going to talk about pleading a little bit, that can make it difficult if you want to, particularize these allegations. And it can also make it difficult sometimes to know whether the bad faith conduct is there or not. I always want to talk to the clients and find out what their perspective on things is and how they feel they've been treated. I can't tell you how many times I asked Sarah at trial in response to something that happened on her file, how she felt about how she was treated. And I just got fantastic answers. I remember her talking about discussions she had with the adjuster where she felt like she was being re-victimized by certain things that were being said to her. So I guess that's a little separate and apart from the claim file, but that's in the claim file too. The claim file should have telephone logs. It should have memos or correspondence that sets out every interaction between the claims handler and the our clients. I'm looking at the adjuster management plans, how they've updated them, what they're doing around the time of denial, who they're sending the files to. When they send files to medical consultants, what are they sending them Are they sending them full files? When they're providing a history, are they providing a full history? Or are they cherry picking from information, cherry picking information?
Are they doing paper reviews?
Are
And
they
are
doing
they
paper
having,
reviews?
are they having a GP trump a psychiatrist or a
Absolutely.
radiologist? You know,
Absolutely.
in terms of pleading it, one thing that you said, and I agree with you, sometimes you don't have the file. I'm going to say this. If they don't give me the file, because that's the first thing we do, we write for the file usually before we issue. We write to the file day one. If they don't give us the file or there's holes in the file, I believe in pleading bad faith. Don't do boilerplate. I find that's just going to piss the insurers off, okay? Try and put enough specificity into the claim that when counsel looks at it, not the adjuster, but counsel will say, oh, you got something here, right? So plead. They refuse to give me the whole file. They refuse to give me the medical file. They had improper medical people doing appeal. And I'm going to say this, one of these internal consultants that comes into an insurer 3 days a week that is a GP and says, oh, the psychiatrist is wrong. Oh, the oncologist is wrong. To me, that's evidence of bad faith. That's sort of a pattern of behavior.
I totally agree. I mean, that was one of the, I think, discovery admissions. We could talk about discovery as well. But, I asked about the internal medical consultants and how they chose these people. And they were all GPs. And the answer was, we just go to the next person on the list, right? So here you have on one side, you've got an opinion from a world-renowned neurosurgeon supporting a disability. And on the other side, you've gone to a GP who was just next on the list. It's that type of juxtaposition that I think, for those who have looked closely at the Court of Appeal decision, those were things that they put a lot of emphasis on, and in terms of the bad faith component here.
So, I mean, that brings us sort of to the discovery, and my practice on the discovery, by the way, is unless everyone else in the insurance company is dead, okay, I never, ever, ever want to do the professional witness, the claims, management person or whatever it is they call them, the litigation consultant. That person's never worked on the file. They're a professional witness. They're very, very good, and it's hard to get something from them, right? So I always have my law clerk, who's been with me for 30 years. She goes through the file with a fine-tooth comb, and she creates a short list of 2 or 3 people, and you can get gold. I had a case years ago where they cut my client off, a nurse, based on a telephone interview from a woman in Florida. I brought her up for discovery, and she admitted she had no medical training. She had a GED education. She didn't know Canadian law at all. She didn't know what CPP disability was. Okay. She didn't know anything about our medical system. She didn't know anything about our healthcare system. She'd never been in a hospital. My client was a psychiatric nurse. And I never would have got admissions like that unless I had picked the lowest decision maker. Who were you able to examine on this file, Steve? And did you get any nuggets of gold from the discovery?
So I examined the last appeals handler who made the final decision to deny the claim. This would not have been my first choice. I do the same thing you do, Steve. I go through the file. I want the person who has been most involved in the file, typically someone who's had a lot of communication with my client, who knows the claim and who said some things in the claims file that I think are going to be very easy to examine them on at discovery. That's the person I would want. That person was no longer with the company. In fact, couldn't even get, Blue Cross wouldn't give me that individual's contact information until the first day of trial. I had to bring a motion for it. When I finally did get the contact information, it turns out it was outdated contact information, but that's a segue. I'm getting off topic, but credit to Brendan on this one as well, because in your recent decision, you were able to get all contact information for claims handlers who currently with the company and former claims handlers as well. So that's very important. But yeah, I agree with you, Steve. You want the person who's been very involved in the file. Preferably, you absolutely do not want the litigation specialist who the insurance company will always propose. They have no direct knowledge about the claim.
Did you have to bring motions for productions post-discovery on this case?
I did not bring any motions for production. I probably should have brought some for some of the witness information. So instead I was left seeking that at the beginning of the trial. But no, I didn't bring any. I mean, like I said, the file was relatively comprehensive, but there were a couple pieces of missing information that I could have moved on and didn't. So
So in
I
the
think it's-
in the 5 minutes we have left, because we're rapidly running out of time, let's talk about, Steve, trial considerations and takeaways. So you've got the bad faith case, right? So I'm not, this seminar is not about typical trials, because we could talk for days about that. But in the bad faith case, I had a case once against Manu. They wouldn't even admit that the company made the money they made in their claims manual, or in their website. I went onto the website and said, look, you got all this money that you say you're making. I just want to be able to say you're a $3 billion corporation. You wouldn't say that. I actually put the CEO under summons. I got such blowback about that. But I said, Gary Will had this in Pilot and Witten talking about the profitability of the company. It's funny, when the CEO was under summons, all of a sudden they were willing to admit the website, right? In terms of the size of the company, I mean, one of the comments that somebody made somewhere was, a punitive award like this in your case wouldn't even get noticed unless it was a number like that, right?
Mhm.
How do you go about in front of a jury, in front of a judge, establishing this is a big ass company, and if you want to get their attention, you got to hit them with a big ass award, Steve?
That's a really good question. That's a really good question, because I mean, I look at the Court of Appeal decision here, and Justice Hergen took judicial notice of the fact Blue Cross is a large insurance company, and that the $1.5 million was a little more than a rounding error to them. But the jury did not have that information in front of them. I think we got to give juries credit, give them the benefit of that they know these things. They know they're dealing with an insurance company. Certainly, there's information I think you could get from public sources and put to deponents on discovery. You may have the ability to examine on financial information. I know that issue, though, it came up in this recent RBC case, and the decision is a little convoluted because it suggests a possible bifurcated process of liability being bifurcated from punitive damages or a bad faith claim, which doesn't
I
make any
see that
sense.
case. I guess what I want to tell the panelists is, old but true. If you go back to the Pilot and Witten case, and you read what the court said about financial information in Pilot and Witten, if you really think you got a bad faith case, I think you should seek to file their public financial statements. Most of these companies, you can go onto their website or something. You can see the assets that are there. You might not get them in, but I don't like this concept of not being able to tell the juries. These are the biggest companies, right? These LTD companies make auto insurance companies look small. And we've got to be able to tell juries that information, because like the Court of Appeal said, $1.5 million to Blue Cross, it's a rounding error.
Right.
So now, Steve, in the 20 seconds we have left, any final message to everybody watching this? And I want to thank everybody that took the time to watch this today.
Yeah, thanks, Steve. I echo your comments earlier about these cases being important. They take a lot of effort. You got to be prepared to fight everything. The Court of Appeal made a comment about Sarah having the stamina to pursue something like this. Not every litigant does, right? So you know your client, determine whether there's someone that can manage this process. And then it's on us as lawyers with the right clients to be pursuing these cases. Because I'll just close with this. I don't think in the 20 years between Witten and Blue Cross that there weren't egregious cases of claims mishandling and bad faith that couldn't have warranted an award in excess of 7 figures. I'm sure there were cases like that, but we didn't see them. And the reason we didn't see them, I suppose, is because those cases either weren't brought or were settled along the way. And I think we owe it to each other and our clients to pursue these cases. And when we see bad faith conduct and we have clients that are willing to pursue these claims, that we take them the distance to generate the precedents like Baker. And I hope there are many more cases like this in the future that continue to move the dial.
I think there are those cases out there. I've started a couple of them over the last 20 years. Here's my experience. The case is settled. They settle 4 days in, 8 days in to a trial. You know, good on you for doing this case. Kudos to you. I've had many cases start with LTD companies. I haven't had one finish. If folks out there show them that they're willing to go, then I think we can move the needle for all of our clients.
Totally agree.
So, listen, everybody, I want to thank everybody for coming. I don't know if our friends at LexisNexis are going to take over now, but I know we're under a clock, so we appreciate everybody's time today. And Stephen, thank you for taking my call and agreeing to talk to me about this wonderful case.
Thanks for having me. A pleasure and an honor to collaborate with Gluckstein lawyers here at Thomson Rogers. Always great to work with other law firms. And thank you, LexisNexis, for hosting today.
Thank you, everybody, for joining us. I'm looking in the chats, lots of comments about what a great presentation it was, and somebody's canceling their Blue Cross. So, but thank you, everybody. We will make sure that contact information for both Steve and Stephen is available when the video is sent or the recording is sent out. And again, a reminder, you will receive a recording of this presentation for anyone who did attend. Thank you, everybody. Have a wonderful day. Thank you again for joining us. Thank you to our presenters. And I wish everybody a great day.
Thanks, Alex. Thanks, Brenda. Thanks, Stephen.
Thanks. Bye-bye.